So today we are talking about the freedom of speech and expression. We are trying to compare the laws relating to it between India and USA. So let's begin by laying the groundwork with the United States. Their foundational principle, enshrined in the First Amendment back in 1791, states quite directly, Congress shall make no law abridging the freedom of speech or of the press. On the surface, that seems like a pretty absolute guarantee.
It does read that way, and that's certainly the starting point for understanding American free speech doctrine.
Right.
However, the Supreme Court has played a crucial role in interpreting and refining the scope of this right over time.
Yeah.
It hasn't always been seen as entirely without limits.
Absolutely. And when we think about the evolution of this, the early 20th century brings us the landmark case of Schenck v. U.S. in 1919.
Yes.
What was the key principle that emerged from that decision?
Schenck rose during the First World War.
Right.
And it was in this context that the Supreme Court articulated the clear and present danger test.
Okay.
Essentially, the court said that speech could be restricted if it posed a clear and present danger of bringing about substantive evils that Congress had the power to prevent.
Okay.
A classic example often used to illustrate this is falsely shouting fire in a crowded theater, where the speech itself creates an immediate risk of harm.
That makes sense. Speech that directly incites imminent danger isn't protected.
Right.
But the legal standard evolved significantly from that initial clear and present danger test, didn't it?
It did.
I'll go.
Over time, the clear and present danger test was seen as potentially too broad.
Right.
The standard that is largely in place today comes from the 1969 Supreme Court case, Brandenburg v. Ohio, which established what's known as the imminent lawless action test.
Yes.
What's particularly significant for your understanding is how this standard makes it incredibly difficult to prosecute speech based on its content alone, even if that content is abhorrent. The focus is almost exclusively on the direct and immediate risk of illegal action, a very high bar to clear.
So the imminent lawless action standard really narrowed the government's ability to restrict speech compared to the earlier clear and present danger test.
Yes.
It requires both an intent to incite illegal activity and a high likelihood that such activity will occur imminently as a direct result of the speech.
Precisely. This means that even speech that is deeply offensive, hateful, or critical of the government is generally protected under the First Amendment.
Right.
Unless it directly and immediately incites violence or other unlawful conduct. It's this high threshold that explains why the U.S. doesn't have broad hate speech laws in the way that some other countries do.
Okay.
The legal framework prioritizes the protection of even unpopular or controversial viewpoints unless they cross that very specific line into inciting imminent illegal action.
Okay.
Similarly, under U.S. law, the legal definitions of obscenity and defamation are also quite narrow, reflecting the strong emphasis on freedom of expression.
Okay, that gives us a solid understanding of the U.S. legal framework and how it has evolved.
Yes.
Now let's turn our attention to India.
Okay.
The constitutional guarantee of free speech there is found in Article 19 of their constitution, correct?
That's right.
Okay.
Article 19 guarantees the right to freedom of speech and expression to all citizens of India. However, it's absolutely crucial to immediately look at the very next part, Article 19(2).
Yes. The crucial clause that outlines the reasonable restrictions.
Right.
This is where we see a really significant departure from the American approach, isn't it?
Indeed.
Yeah.
Article 19(2) lays out a number of grounds on which the Indian government can impose reasonable restrictions on the freedom of speech and expression.
Right.
These include considerations related to the sovereignty and integrity of India, the security of the state-friendly relations with foreign states, public order, decency, or morality, contempt of court defamation, or incitement to an offense.
Yeah.
This reflects a different philosophical underpinning where the state plays a more active role in maintaining social order and preventing offense, rooted in a history of managing a highly diverse population with a potential for social unrest.
Right.
This contrasts with the American emphasis on individual liberty and a more laissez-faire approach to the marketplace of ideas, even if it leads to discomfort or offense.
That's a much more extensive list of permissible restrictions compared to the narrowly defined exceptions in the U.S.
Right.
Terms like public order, decency, and morality seem particularly broad and open to interpretation.
That's a key point.
Okay.
These terms inherently allow for a wider scope of governmental intervention.
Right.
Furthermore, it's important to remember the First Amendment to the Indian Constitution, which was enacted in 1951.
Yes.
This amendment specifically broadened the restrictions under Article 19(2) to explicitly include public order, and friendly relations with foreign states, further expanding the legal basis for limiting speech.
So, from the very foundation of their legal systems, we see this fundamental difference.
Exactly.
The U.S. starts with a broad protection and carves out limited exceptions based largely on the immediate risk of harm.
Yes.
While India guarantees the right, but immediately qualifies it with a substantial list of areas where that right can be reasonably restricted by the state.
Exactly.
Okay.
This difference in the architecture of these constitutional provisions has very tangible consequences for how freedom of speech is experienced and dealt with legally in both nations.
This theoretical comparison is really insightful.
Yes.
But I think it becomes even more concrete when we look at real-world examples.
Right.
And what better way to see these differences in action than by examining the experiences of comedians in both countries,
Yes.
who often test the boundaries of acceptable expression.
That's an excellent way to illustrate these abstract legal concepts.
Right.
Comedians, by the very nature of their profession, often engage with sensitive topics and push societal norms, making their experiences a fascinating lens through which to view the practical application of free speech principles.
Let's start by looking at some cases involving comedians in India.
Okay.
Back in 2016, we saw the arrest of Kiku Sharda.
Yes.
What were the circumstances surrounding that?
Kiku Sharda, a well-known television actor and comedian, was arrested for mimicking a religious leader,
Right.
Gurmeet Ram Rahim Singh, during a comedy show.
Okay.
The legal basis for his arrest was Section 295A of the Indian Penal Code.
Right.
This section criminalizes deliberate and malicious acts that are intended to outrage the religious feelings of any class by insulting their religion or religious beliefs.
So the act of comedic mimicry, which some individuals found offensive to their religious sentiments,
Yes.
led to a criminal charge and arrest.
Right.
That stands in stark contrast to the U.S. legal landscape we were just discussing.
It does.
Right.
In the U.S., under the First Amendment and the Brandenburg Standard, it would be extremely difficult for such an act of parody, however offensive some might find it,
Right.
to be considered incitement to imminent lawless action.
Yes.
The focus in the Indian case is clearly on the potential to cause outrage to religious feelings,
Right.
which is a specific ground for restricting speech under Article 19(2) and Section 295A of the IPC.
Then we have the really concerning case of Munawar Faruqui in 2021.
Right?
He was actually arrested before he even performed the jokes he was accused of planning to tell.
Yes. The case of Munawar Faruqui in Madhya Pradesh is a particularly telling example.
Okay.
He was arrested based on allegations that he was planning to make jokes about Hindu deities during a comedy show that hadn't even taken place yet.
Yeah.
He was charged under Section 295A of the IPC,
Right.
similar to the case of Kiku Sharda, as well as Section 269 of the IPC,
Okay.
which relates to negligent acts likely to spread infection of disease dangerous to life.
Oh, wow.
A charge that seemed quite unrelated to the allegations about his planned jokes.
Right.
The fact that the arrest was preemptive based on anticipated speech deemed likely to offend really highlights the potential for restrictions on expression in India even before it occurs,
Yeah.
if it's perceived as likely to cause offense or disrupt public order.
And we also have the ongoing situation with Kunal Kamra,
Right.
who has faced multiple First Information Reports, or FIRs, for his tweets that were critical of politicians.
Yes.
For our listeners who might not be familiar with the Indian legal system, an FIR is essentially a police complaint that can trigger an investigation.
That's a helpful clarification.
Yeah.
Yes, Kunal Kamra has been the target of several FIRs, primarily alleging defamation under Section 500 of the Indian Penal Code due to his critical social media posts about political figures.
Okay.
Additionally, and perhaps even more significantly, he faced contempt of court proceedings initiated by the Supreme Court of India itself because of his tweets about the judiciary.
Right.
His refusal to retract those statements further emphasizes the sensitivities around criticism of institutions in India and the potential legal ramifications.
It seems even established comedians like Veer Das have faced repercussions. In 2021, his I Come From Two Indias monologue,
Right.
while not resulting in arrest, did lead to police complaints and considerable public backlash,
Yes.
with some viewing it as defaming the nation.
That's right.
Okay.
While Veer Das wasn't charged under specific sections of the IPC in the same way as Kiku Sharda or Munawar Faruqui, the police complaints lodged against him and the intense public criticism he faced.
Yeah.
For speech perceived as critical of India, illustrate how even broader interpretations of causing offense or harming national sentiments can lead to significant repercussions for artists in India.
More recently, in 2025, we saw the case involving Ranveer Alabadia,
Right.
also known as Beer Biceps,
Yes.
who faced obscenity charges related to comments made on his YouTube show.
Uh-huh.
The Supreme Court did grant him protection from arrest, but also temporarily prohibited the airing of that particular content.
This case, again, highlights the application of restrictions based on decency and morality.
Right.
Which, as we discussed, are permissible grounds for limiting free speech under Article 19(2) of the Indian Constitution.
Right.
The Supreme Court's involvement in granting protection from arrest while simultaneously restricting the dissemination of the content underscores the ongoing tension between freedom of expression and these societal values in the Indian legal system.
It really paints a picture of a much more legally constrained environment for comedians.
Right.
And by extension, for freedom of expression in general in India compared to the United States.
Yeah.
Now, when we look at the U.S. side of things,
Okay.
one of the more prominent historical examples involving a comedian pushing boundaries was Lenny Bruce in the 1960s.
Lenny Bruce was a truly groundbreaking figure.
Right.
Who relentlessly challenged societal norms and used very provocative language in his stand-up routines.
Okay.
He faced numerous arrests throughout the 1960s on obscenity charges.
Wow.
These legal battles were really significant in shaping the ongoing debate about the definition of obscenity and the limits of free speech in the U.S.
Mm-hmm.
It's worth noting that he was eventually posthumously pardoned in New York in 2003.
Okay.
Which really speaks to how much societal attitudes towards freedom of expression evolved in the decades following his prosecution.
And then in the 1970s, we have the famous incident involving George Carlin's 7 words you can never say on television routine, which led to the FCC v. Pacifica Foundation Supreme Court case in 1978.
That's a really important case to consider, but it's crucial to understand its specific context.
Oh.
Carlin's routine was broadcast on a public radio station, and the Federal Communications Commission, or FCC, received a complaint about it.
Right.
The Supreme Court ultimately upheld the FCC's authority to regulate indecent material broadcast over public airwaves.
Okay.
However, the key takeaway here is that this wasn't a broad legal restriction on Carlin's ability to say those words.
Right.
The ruling was specifically about the regulation of content on publicly owned broadcast channels, particularly concerning material that might be accessible to children.
Right.
It didn't make those 7 words illegal to say in other contexts,
Yes.
like a live comedy show or even on cable television.
That distinction is really important.
It is.
It wasn't a blanket prohibition on the speech itself,
All right.
but a regulation specific to broadcast media and considerations of public airwaves and accessibility to children. Now, when we look at the more contemporary landscape in the U.S., it seems like legal action taken against comedians for their jokes is actually quite rare.
It is.
Instead, the consequences they face tend to be more in the realm of social or corporate repercussions.
Right.
What's often referred to as cancel culture.
That's a very accurate observation.
Okay.
While comedians in the U.S. can certainly face significant public criticism, boycotts, and even lose performance opportunities or endorsements due to controversial or offensive material, legal intervention by the state based on the content of their jokes is much less common today.
Okay.
The example of Shane Gillis being fired from Saturday Night Live after past offensive jokes resurfaced
Right.
is a good illustration of this.
Go ahead.
While there were significant professional consequences for him, it was a decision made by a private entity in response to public pressure, not a legal punishment imposed by the government.
Right.
This distinction between private consequences and state censorship is a really fundamental aspect of the First Amendment framework.
So when we draw a comparison between the protections afforded to comedians and more broadly to freedom of speech,
Yes.
in the U.S. and India, the differences are quite striking.
Legally, the frameworks are almost at opposite ends of the spectrum.
Right.
The U.S. provides a very wide shield of protection with very narrowly defined and high bar restrictions, primarily focused on that direct incitement to imminent lawless action,
Yes.
along with a very narrow definition of obscenity and defamation.
Yeah. Right.
India, while constitutionally guaranteeing the right to free speech,
Right.
immediately qualifies it with a far-reaching list of restrictions
Yeah.
that can be invoked based on broader and sometimes more subjective criteria like public order or morality.
Right.
And this fundamental legal difference really plays out in the lived experiences of comedians in each country.
Right.
In India, we see frequent legal actions, the filing of FIRs, and even preemptive arrests based on the potential for offense. In the U.S., while there can be significant social and professional fallout from controversial speech, legal intervention by the state to restrict comedic expression is much less common.
Exactly. The cultural context also plays a significant role in how these legal frameworks are applied and perceived.
Absolutely.
India's incredible diversity and the historical context of managing a pluralistic society mean that speech, particularly concerning religion and caste, can be incredibly sensitive.
Yes.
This can lead to a greater propensity for individuals and groups to feel offended,
Uh-huh.
and for authorities to feel a need to intervene to maintain social harmony.
Right.
In the U.S., there's a stronger cultural norm that generally favors a more robust tolerance for even highly offensive speech
Yes.
in the name of a free marketplace of ideas.
Uh-huh.
Although, as we've just ongoing debates around cancel culture indicate that the social boundaries of acceptable speech are continually being negotiated.
Yes, that's right.
It's also important to recall the Shreya Singhal v. Union of India case from 2015. While this was a significant ruling by the Indian Supreme Court, that struck down Section 66A of the Information Technology Act,
Okay.
a law that had allowed for broad and somewhat arbitrary restrictions on online speech.
Right.
It's crucial to remember that this ruling didn't fundamentally alter the broader constitutional balance regarding restrictions on free speech in India.
Right.
The extensive grounds for limiting speech under Article 19(2) and various sections of the Indian Penal Code remain in effect.
That's a critical point to underscore.
Yeah.
Shreya Singhal was certainly a welcome step towards greater freedom of online expression in India by removing a particularly problematic piece of legislation.
Right.
However, it didn't change the underlying constitutional framework that allows for a much wider range of restrictions on speech compared to the U.S.
Okay.
The fundamental differences in how these two democracies approach the balancing act between free expression and other societal values remain.
So to bring it all together,
Okay.
the core difference we've explored today is that the U.S. legal system places a very high premium on the freedom of speech,
Yes.
establishing very specific and difficult-to-meet criteria for any restrictions, powerfully exemplified by the Brandenburg test.
Right?
In contrast, the Indian constitutional framework,
Yeah.
while guaranteeing the right to free speech, permits much broader governmental intervention in the name of maintaining things like public order and morality,
Exactly.
which, as we've seen through the examples of comedians, often leads to a more frequent use of legal measures to regulate expression.
That's a concise and accurate way to summarize the key distinctions.
Okay.
This fundamental difference in their legal architectures has a very real and tangible impact on artists and individuals in both countries.
Right.
The examples of comedians facing legal challenges far more often in India than in the U.S. clearly illustrate this disparity in the practical application of free speech principles.
Considering these significant differences in how these two of the world's largest democracies approach this fundamental right, it really prompts a deeper reflection.
Absolutely.
What does it tell us about how each society prioritizes and balances this crucial right alongside other deeply held values, such as social harmony and public order?
Right.
This comparison really offers a lot to think about regarding the complex role and inherent limitations of free speech within any democratic society.
It really does.
Thanks for listening, everybody.
Yes, thank you.